In a tense and chaotic courtroom moment, a routine eviction hearing quickly turns into an unbelievable showdown between a judge and a tenant who refuses to accept the reality of her situation. The woman, who had been living in a property she no longer owned, attempted to stop the eviction by arguing that the foreclosure itself was invalid. She claimed the case should actually be handled in federal court and insisted the entire process was unlawful. But the situation took an even stranger turn when she repeatedly told the court that she was not only a lawyer, but also held a PhD. The judge, clearly frustrated, tried multiple times to explain that the property had already been foreclosed and that the current case was simply about eviction. However, the tenant continued interrupting, challenging the court's authority, and attempting to argue legal technicalities that didn't apply to the situation. At one point, the judge had clearly had enough. He warned the woman that addressing the court improperly could get her into serious trouble, but instead of backing down, she pushed even further, trying to modify the case documents and add new parties to the case without following the proper legal procedures. That decision backfired immediately. The judge struck her pleadings from the record and made it clear that her tactics would not delay the process. Then came another major problem for the tenant. She hadn't paid rent in months. Because of that, the judge ordered her to begin paying $5,000 into a court escrow account starting March 1st if she wanted the case to continue. With tension still high and the courtroom visibly exhausted by the confrontation, the judge finally adjourned the hearing until March 14th. But one thing was clear: this courtroom battle was far from over.
Czar, Sadehi Stanfield, and Gazal Stanfield.
Ready, Your Honor. Good morning. Anthony Mamina, appearing on behalf of Plaintiff R&J Group Holdings, LLC.
You got either party here.
Good morning, Your Honor. My name is Azar Stafford.
All right. And this is a termination.
Yes, post-lease term termination. We're not seeking to terminate for non-payment, Your Honor, just because the lease has in fact terminated.
The lease has expired.
Yes.
All right, ma'am. What's your position on that? They're seeking to terminate your tenancy. Your lease has expired.
Good morning, Your Honor. This is not a landlord-tenant case, Your Honor. This is the owner of record versus the real owners of property, which are us.
Pardon?
Yeah, we are the real owners of the property. This property was wrongfully foreclosed. This property, I petitioned for a stay because our case against Wells Fargo is pending in federal court, and we want Your Honor to issue the stay because we also notified Mr. Mamina that is in fact them that are violating their contract, because this was not a tenancy. This was a lease with option to buy. We have been notifying them that we are ready to purchase the property since it has been 2 liens gone on the property. Our mortgage is ready, our down payment is ready, and then they cannot remove the liens, Your Honor. And the liens are one from Ann Arbor Township. So unless R&J Group remove the lien, we cannot proceed with our mortgage to purchase the property. And this was our plan B to begin with. Our plan A is our case pending in federal court for wrongful foreclosure. So I want to petition for a stay before this honorable court.
Well, I'm not going to grant a stay if that's what you're asking for. However, you say there's an action that's pending in federal court?
Correct.
Counsel, you know anything about that?
No, as a matter of fact, I do know something about that, Your Honor. What they're claiming is that there was a foreclosure started by Wells Fargo, and Wells Fargo failed to honor. They're claiming, we don't believe that's the case, and the pleadings bear that out, failed to do the necessary post default workout as required by some of the COVID statutes relating to defaults and mortgage defaults. It has nothing to do with us. We are not a party to that suit. We haven't been served with it. As a matter of fact, I've been advised by your office or the clerk in the court that Ms. Staffeld, who incidentally is a Juris Doctorate, as I'm told by her, and a PhD and other advanced degrees, so she's not uninformed here, Your Honor. This is in fact a lease with an option to purchase. That's it. It is what it is, and I've provided a copy. It's not. She does not own the property. My client is the record owner of the property. We agreed to lease it back to her. She was the former owner. She lost it in the foreclosure, which is the subject of the federal action that involves Wells Fargo, not my client in any regard.
Well, hold on a second. So,
Go get the Wells Fargo from the bank.
hold on. So that I'm trying to follow this. Wells Fargo foreclosed on the defendants in this case. Right. Your client is the purchaser from that foreclosure?
Yes, Your Honor.
And she's challenging the foreclosure in federal court. All right, here's what I'm going to do, folks. I'm going to adjourn this out 1 week to the 28th, 2025 at 1 p.m. At 3 p.m., excuse me. Ma'am, you are to file an answer to this complaint along with information regarding the federal lawsuit. I understand that plaintiffs in this case aren't a party to that, but I'd like to at least take a look at that before issuing any ruling on this case. So you'll need to file an answer. It should include not only references to that federal lawsuit, but I'd like a copy of the complaint and answer also on that.
Absolutely, Your Honor.
All right.
Thank you, Your Honor.
Can you extend that 1 week to 2 weeks?
Do you have any objection to that, Counsel?
I certainly do, Your Honor, but of course.
Okay, then I'll do what the set. We'll go 1 week out, folks.
Thank you so much, Your Honor.
3 p.m.
Thank you, Judge. Have a nice day.
Our $J Group Holdings versus Azar Segdahi Safeld. Okay. So, what was that?
Ready, Your Honor.
Good afternoon, Your Honor.
And where are we on this?
May I pass to the bailiff to hand this to the...
What is it?
This is the petition for joinder before federal court we filed, Your Honor.
The petition for joinder?
Yes. We amended the complaint and we added R&J Holding to our federal complaint in U.S. court.
No. Have you seen that?
I have not, Your Honor.
Well, you can't just give me things and expect the court to take them without showing opposing counsel.
Okay, I have a copy for him. He refused to accept it.
Your Honor, she hasn't tendered it to me. Also, for what it's worth, yesterday at about 11 o'clock in the morning, the defendant served upon my office a ream of pleadings, responses, motions to stay, motions to dismiss, and so on. And I did my best.
For what case? For this one?
For this case. We're not a part of that federal case, and she is doing the classic attempting to turn this into a federal case when in fact it's just a summary proceedings action, Your Honor.
Absolutely not, sir.
And I did also give her copies of everything I filed by overnight mail and today. I handed it to her a while ago and she gave it back to me. I'm not going to fight over it, but they served me with a series of motions. I had to respond.
I don't have any motions.
Well,
Yes, Your Honor, the package in front of you has a motion to dismiss has petitioned for a stay, has answered to the complaint. and
Okay,
has
you
a
filed
counter
these
complaint.
today? Yeah.
No,
today.
we filed it yesterday, Your Honor. You only gave us a week to answer. Remember, Your Honor?
Your Honor, you gave her.
Oh, ma'am, I remember everything I do. Do not try to address me that way. I will have a memory that will throw you in circles. So don't come at me like that. Because if you come at me like that, you're going to get hurt.
I respect.
Counsel, what were you saying?
Your Honor, I was saying that as I recall, and I wouldn't challenge your memory, you may as well, when we were appeared and she asked for the opportunity to present some reference to this federal case, you said, we're going to adjourn this till next Friday at 3, and you can deliver to me a copy of that federal case so that I can look at it, not file a whole host of other pleadings and other matters at the last minute. I mean, that was tough for me to handle, but I got it out, Judge.
Well,
A copy of federal pleadings is part of that package that was hand-delivered to this gentleman and to the court, Your Honor.
This courtroom video is one you have to see to believe. From the moment the hearing begins, it's clear that this is not going to be an ordinary eviction case. A woman who no longer owns the property she's living in arrives determined to stop her eviction by taking her fight all the way to federal court. She insists that the foreclosure is invalid, that she has rights beyond what the law allows, and repeatedly claims that she is a lawyer and holds a PhD. The confidence with which she asserts her authority immediately sets the stage for tension, confusion, and frustration that only escalates as the hearing progresses. The judge opens the hearing with patience, trying to maintain order, but it doesn't take long for him to recognize the challenges ahead. The woman interrupts repeatedly, questions the court's authority, and insists that the proceedings are unlawful. Her voice is calm, but her arguments are relentless. She questions every ruling, pushes legal boundaries, and acts as if her qualifications place her above the law. Judge Simpson responds firmly, warning her that addressing the court improperly could result in serious consequences. From the start, it becomes clear that this hearing is not going to follow the normal flow of courtroom procedure. Every word she utters seems designed to provoke, challenge, or disrupt. As the hearing continues, her tactics grow increasingly desperate. She attempts to change the case caption and add parties who have no connection to the matter, a clear violation of legal procedure. The judge recognizes this immediately and strikes her pleadings, sending a clear message that the courtroom will not tolerate manipulation. But she refuses to back down. She continues arguing, insisting that her knowledge, her degree, and her legal expertise give her the right to override the court. Her claims grow bolder with each passing minute, and the tension in the room becomes almost palpable. The financial dimension of this case further heightens the stakes. The tenant hasn't paid rent since November, and Judge Simpson orders $5,000 to be paid into a court escrow account starting March 1st. This is not just a penalty, it's a decisive move that shows the court will enforce the law, no matter how loudly she protests or how confident she believes herself to be. Yet despite the looming financial consequences, she continues to argue, trying to distract the court with technicalities and legal jargon that do not apply to the case. Her insistence on challenging authority makes the courtroom feel like a battlefield. For more than an hour, the courtroom witnesses a clash between defiance and authority. The woman refuses to accept reality, continuing to interrupt, question, and attempt to manipulate the proceedings. Judge Simpson remains firm, patient at times, but visibly exasperated. His repeated explanations fall on deaf ears, yet he does not lose control. Every strike of her pleadings, every warning, every procedural correction adds to the tension. The audience can sense the struggle, someone claiming legal mastery against the immovable authority of the court. Her attempts to disrupt the case are relentless. She interrupts witnesses, tries to challenge rulings, and attempts to assert control over the process. Each of her arguments, no matter how unfounded, forces the judge to pause, explain, and reaffirm the rules. The courtroom becomes a stage for chaos, a place where procedure, law, and authority collide with defiance, manipulation, and audacity. Spectators watch in disbelief as someone who claims legal and academic expertise continues to clash with the fundamental principles of the courtroom. As the hearing progresses, Judge Simpson enforces order firmly. He strikes pleadings, reiterates the importance of procedure, and makes it clear that attempts to delay the case will not be tolerated. The financial consequences, procedural corrections, and repeated warnings combine to show the woman that her claims, no matter how confident, do not override the law. The tension escalates with every argument as she continues to test the limits of courtroom patience and authority. This hearing is more than just about eviction. It becomes a dramatic display of human behavior under pressure, a lesson in how authority, procedure, and law intersect with defiance and ambition. The woman's repeated interruptions, attempts at manipulation, and insistence on asserting authority make this one of the most memorable courtroom encounters in recent memory. Her claims of PhD-level knowledge and legal expertise create a stark contrast against the clear, structured, and unyielding procedures of the court. Judge Simpson handles the situation with a balance of firmness and professionalism. He maintains control, enforces rules, and ensures that the proceedings continue despite repeated disruptions. His decisions, striking pleadings, ordering escrow payments, and warning about procedural violations, underscore that the courtroom is a place of law, not personal authority. For anyone watching, the dynamic between the tenant's defiance and the judge's authority is fascinating. By the end of the hearing, the consequences for the tenant are clear. The pleadings she tried to manipulate have been struck, the financial obligations are firmly set, and her repeated attempts to defy the court's authority have been formally addressed. The judge adjourns the case until March 14, 2025, marking a temporary pause but leaving the weight of the day's events lingering. This hearing demonstrates the limits of personal claims when faced with established legal procedure and authority. Throughout the hearing, the audience witnesses a lesson in accountability, law, and human behavior. The woman's defiance, persistence, and attempts at legal maneuvering collide with the structured, measured authority of Judge Simpson. Every interruption, every argument, and every procedural challenge becomes part of a story that is both dramatic and educational. The courtroom becomes a microcosm of larger principles: authority versus defiance, law versus manipulation, reality versus perception. As she leaves the courtroom, the consequences are clear. She faces a financial obligation, procedural restrictions, and a legal system that will not allow defiance to dictate the outcome. The video leaves viewers with a lasting impression. In the courtroom, the law is absolute, and no amount of claimed knowledge or defiance can change that reality. This video is a stark reminder that the courtroom is not a place for personal theatrics. It is a place where procedure, law, and authority hold the ultimate power. Attempts to manipulate, delay, or claim unearned authority are met with consequences. It's a rare and fascinating glimpse into how the legal system handles someone trying to challenge its rules at every turn. For those watching, it's not just entertaining, it's educational. The combination of defiance, procedural violations, financial consequences, and courtroom authority makes this one of the most remarkable legal encounters you're likely to see. It's a perfect example of how the law enforces order, ensures fairness, and reminds everyone that no one is above it, no matter their claims or credentials. By the time the hearing ends, the courtroom has experienced chaos, frustration, drama, and a firm reaffirmation of the law. The woman leaves with her challenges addressed, her financial obligations clear, and the judge's authority firmly established.
For that federal case, Your Honor, at this point, she has a case against Wells Fargo, who was a prior mortgagee in the case. Nothing to do with it whatsoever. We're the deed holder of the property.
There's also been a parties added.
Which they counterclaimed against us yesterday at 11 o'clock in the morning and filed several motions. No parties have been added to this case, but she says she wants to add us to that federal case, and I encourage.
Well, the caption is changed.
Correct.
You can't just change the caption.
Well, we haven't been served. And I got the document.
Counsel, I get it. I'm just saying, this caption that I have on your documents is not the caption of this case.
I'm sorry?
The caption here, who is Carl Stafford?
Carl Stafford is here. He's my.
I don't care if he's here. He's not, he wasn't a party to this case, was he?
No.
It says all residents of the house, and he's the resident of the house.
You can't just change the caption.
What do you suggest I do, Your Honor?
You don't want to hear that. I suggest maybe you get an attorney, because I just don't.
She is an attorney, Your Honor.
Well, that's even more alarming. I don't even know what to do with this, because the caption has changed, right?
Yes.
You served motions, and apparently there's a counter complaint that the other side, or whoever was supposed to add, doesn't have an opportunity to answer. I don't even know if there's been a summons issued for these other parties.
Yes, there has.
Are you an attorney?
I'm not a bar license holder attorney. I went to law school.
Counsel, you filed an amended complaint, correct?
I did, Your Honor.
All right.
We have not received that.
I gave it to her.
No, we have not received, sir.
I gave you the packet and you gave it back.
When was that,
Just
sir?
now, I gave it to
You
your
gave
husband.
it to me
You
now.
can have your own darn conversation. You can do it outside. You don't need me here.
I
I'm not going to be a third wheel on a date in my courtroom.
I'm sorry, Your Honor, very sorry. I did give her all of those pleadings and the amended complaint in a white envelope, which she
Did he-
handed back to me.
Did he give you an envelope and then you give it back?
Yes, because
Why?
because I tried to give him the joinder and he gave it back.
She never handed it
This is
anything.
like, this is like kindergarten. I'm going to accept the first amended complaint, counsel. You can serve it on her in whatever way you wish, in terms of either you can do it by email or you can serve it by first class mail. If she won't take it, she won't take it. This, what you filed, which starts out entitled Plaintiff's Defendant's Answer to the Counter, you're going to have to refile this. I'm striking this pleading. You can't just change a caption. Well, guess we're done. And so I'll give you a week to get that out. I realize it delays the proceedings, but I don't think I can do anything else, because I don't know why these parties are running around in this case that you just added to this as the petition to stay is filed on this is crazy. You're gonna have to start over. I'm striking all of that you
Okay.
filed, and you're gonna have to just do it right. I'll take yours, you serve it, they'll have to answer, and then we'll go from there. I don't know that putting it out to next week is gonna do us any good, so I'm gonna put it out to the 14th.
Thank you, Your Honor. I would ask the court if it may. She hasn't paid rent. They haven't paid rent since November. The rent for November, December, and January is $5,000 a month. And the rent for February and March is $5,500 a month. I would ask that you ask them to escrow.
What is the current monthly amount of rent?
It's, there's a holdover provision, but we'll accept the normal rent, Your Honor.
About 5,000?
5,000 for
I'm gonna order escrow.
Escrow, we would pay it in escrow, Your Honor, but not to them, because they have to sell the property to us.
I'm gonna order that you pay escrow to the court in the amount of $5,000. I'm not gonna do a proration back to the original. You'll start that March 1st. It needs to be paid within 7 days of the date of my order, and then needs to be paid each month while this matter is pending. Do you understand that?
Yes, Your Honor.
Please
Thank you,
put
Your
an
Honor.
order to that effect. I will
So
adjourn this.
February rent and March rent?
I can only have March rent.
March.
I could prorate a day February, but
That's not necessary. We'll accept the,
March 14, 2025 at 1 p.m. I feel a cold coming. 1 p.m.
you're on. Have a nice weekend.
Yeah, I will now. All right. Now, give it. Yeah, give it, because, Ann,
Can I take it?
can you what?
Could we submit the joinder or no?
You may, if it is in proper form, submit it anything that you like, but not to me.
Okay.
You can file it with the clerk's office once the file gets up there.
By all means.
Just don't. Just don't. Just
Are we dismissed, Your Honor?
bye. Yes.